Right, wonderful. Thank you so much. Okay, so on behalf of the International Institute for Democracy and Electoral Assistance and the Constitution Transformation Network at Melbourne Law School, I would like to welcome you all to the 6th Melbourne Forum on Constitution Building in Asia and the Pacific. My name's Anna Jejits. I'm one of the conveners of the Constitution Transformation Network, and I'm delighted to chair the opening session of the forum this year. I wish to acknowledge that although we are meeting online, we in Australia are doing so on Indigenous land. And I acknowledge the Ngunnawal people of the lands that I'm speaking from today, the Wurundjeri people on whose land the Melbourne Law School is situated, and the traditional custodians of the lands on which each of you are living, learning and working from today. We pay our respect to the elders past and present and to all Indigenous peoples joining us today. Our theme is democracy, constitutions and dealing with the world. And in 4 sessions, 2 today and 2 on Thursday, we will be considering the different ways in which constitutions have an external face, which defines the people and the state to an international audience and enables governments and other actors to engage with other countries and other entities in the international community. So this is the 2nd year that the Melbourne Forum's been held online. And the great advantage is, of course, that we can welcome speakers and participants from all over the world. This year, our presenters come from 15 different countries in the Asia-Pacific region. Some have participated in the Melbourne Forum before, others are new, and we're delighted to welcome even more people in the audience. I'll explain the logistics for moderating the discussion online later, but for now I do want to draw your attention to the fact that the sessions are being recorded and published online, so please bear that in mind when it comes to using your video and making any comments. And for those of you on Twitter, please feel free to carry on discussions there. The Twitter hashtags are Melbourne Forum 21 and MF6. But first, we'll formally open proceedings with some introductory remarks from representatives of the co-organisers. So I'd like to first invite Lena Rikula Tamang, International Ideas Director for the Asia-Pacific region, to speak. And she'll be followed directly by Dinesha Samaratne from the University of Colombo, who is convener of the Constitution Transformation Network. So Lena, I'll pass over to you now. Thanks.
All right, thank you, Anna. And it is, indeed my pleasure and privilege to welcome you all to the 6th Melbourne Forum, entitled Democracy, Constitutions and Dealing with the World. Warm welcome to our panelists, to our alumni, and to all of you who are joining us today. This is now the 2nd year in a row we are organizing Melbourne Forum as fully virtual, when the still prevailing, even if easing travel restrictions in this region. Though at the moment, it seems that it may be easier to travel from Sydney to Singapore than from Canberra to Melbourne, at least for some. But nevertheless, our Melbourne Forum explores the theme of democracy, constitutions and dealing with the world. And in a minute, Dinesha Samaratne will talk more about why this topic and what were some of the questions we had in mind when developing the concept note. And I would admit that at first, while not skeptical, I was slightly wondering about the topic. But after reading the forum papers from Australia, covering cases from Australia to Afghanistan, from Bhutan to Solomon Islands, and many more countries in between, and alongside with the concept note that Cheryl Saunders particularly put together, I'm confident we are exploring something really interesting here. Just a few words about why Melbourne Forum. Firstly, there is our shared desire by International Ideas as well as of Constitution Transformation Network to build a peer network. We do believe that there is a value in creating a community of practice, can be of support and help in each other's processes if and when invited to do so. And so I'm very glad to see so much of our alumni from the previous forums attending today. Secondly, we have an interest in creating new knowledge insights on the particular themes of relevance in Asia and the Pacific, a region which is so rich with innovative constitutional approaches applied in contexts of extraordinary diversity and complexity, and which should be shared really with the rest of the world. And to date, in addition to the rich library of the country case studies from the past forums, we have now published 8 constitutional insights, which are sort of brief papers investigating a range of topics from the past forums. And I would like to take this opportunity to draw your attention to the 3 latest insights stemming from the last year's forum on representation during emergencies. There is an insight number 6 about legal approaches to responding emergencies, COVID-19 as a case study, written by Charmaine Rodriguez, looking at the use or not of state of emergency legislation in Asia and the Pacific. We had the insight number 7 about how federations responded to COVID-19, written by none other than Cheryl Saunders, investigating the multi-level governance and how it worked in selected countries during the emergency. And insight number 8, beyond a representation, the role of independent and international institutions, including national institutions such as judiciary, election commissions, and international ones, for example, to the WHO. And this is written by Tom Bailey. These papers can be found from Melbourne Forum website or International Ideas website. And they have been, I have to say, they have been very popular to date. And more insights are coming. And thirdly, in relation to still why this forum, the pre-pandemic forums after the initial one in Melbourne in 2016 were organized in the Philippines, in Sri Lanka, and in Myanmar with an aim of being useful for those engaged in constitution building or reform processes on the ground. We used to have sort of one extra day to meet national actors, policymakers, and perhaps we can return to that format next year, who knows. So in brief, this forum is an effort to bring people involved in and fascinated by constitutional issues in Asia and the Pacific region together. And I look very much forward to what our panelists have to say, to comments and questions their presentations may provoke. And I would like to emphasize, and I know Cheryl would like me to say this, that apart from asking questions or clarifications, we wish to encourage you to share experiences from your contexts so that we can as collective gather as many insights on this topic as only possible. Thank you and warm welcome again, and back to you, Anna, or is it directly to Dinesha?
Thank you, Lena. It gives me great pleasure to welcome you to the 6th edition of the Melbourne Forum on behalf of Constitution Transformation Network of the Melbourne Law School. My name is Dinesha, and I'm one of the conveners of the network, and I'm also an academic attached to the Department of Public and International Law at the Faculty of Law of the University of Colombo, Sri Lanka, where I am currently based. In my brief introductory remarks, I will introduce Constitution Transformation Network, the Melbourne Forum, and also the focus of this year's theme, democracy, constitutions, and dealing with the world. As was now already mentioned by Anna and Lena, this is our 2nd virtual forum, and the circumstances which compel us to meet on a virtual platform is an apt reminder of the deeply interconnected nature of life on the planet. Our forum coincides with the UN Climate Change Conference, which too is a reminder of our interconnectedness, and also speaks to the need to think holistically about domestic and international legal systems in responding to the challenges of the world we live in. Now, our theme for this year's forum too reflects this growing awareness that scholars and practitioners ought to probe further the ways in which constitutional text and practice engage with the rest of the world. In a series of 4 online roundtables, we hope to explore the relatively understudied aspects of the external face of the Constitution, including how new constitutions are approved, how constitutions authorize ratification of treaties, how constitutions regulate international investment, and finally, the ways in which subnational legal entities engage in international relations. In these discussions, we hope to go beyond the now familiar discussions about the incorporation of international law in domestic legal systems or international involvement in constitution making. Now, established in 2015, the Constitution Transformation Network is a group of scholars associated with the Melbourne Law School who come together to study constitutions and constitutional practice in the Asia-Pacific region. CTN's work and focus is driven by developments on the ground and is carried out in partnership with scholars and practitioners from and located in the relevant jurisdictions. The Melbourne Forum is centerpiece in CTN's engagements with the region and the world and has been convened in partnership with International IDEA. I think there are 5 unique features to this forum that are worth recalling very quickly here today. The first is the way in which the forum engages in comparison. At each forum, we provide insights on a given theme, on a specific sub-theme from their own context and experience. This format allows participants to speak to their own jurisdiction and to highlight its specificities, but also engage with a regional or global discussion. Each jurisdiction is taken on its own terms at the forum. And in this year's forum, we will hear from experts on Timor-Leste, Afghanistan, and Japan today on international approval of new constitutions. From Indonesia, South Korea, Bhutan, and Singapore on constitutional frameworks for treaties. From Sri Lanka, Papua New Guinea, and the Philippines on constitutional frameworks for international investment on Thursday, followed by Nepal, Australia, Solomon Islands, and India on subnational engagement in international relations. The hope is that by bringing these diverse perspectives together, we can seek to better understand developments on the ground, which could then inform our regional and or global perspectives. The second unique feature is that the Melbourne Forum is non-prescriptive by design and in its outputs. What we aim for is discussion and exchange of experiences and ideas. Participants come to the discussion to listen and to respond to each other's perspectives. Each forum concludes with a session at which the insights gained are identified and analyzed further. We are grateful to the presenters of each session for the excellent papers that they have made available for us this time. These short papers respond to questions that are specific to each subtopic of our theme this year and will guide our deliberations today and on Thursday. The third unique feature is the way in which the agenda for the forum is set. The theme for each Melbourne Forum is identified on a rolling basis. We take into account new ideas that emerge from the Melbourne Forum of a given year, regional and global developments, as well as ongoing research and our own engagements in choosing a theme for each forum. You may recall that last year, the forum was convened on the theme of representation, inspired by the challenges we were dealing with due to the pandemic. This year, we focus on the external face of constitutions, inspired by the numerous conversations at this forum previously and beyond about the dynamics between international law and constitutional law that we see across the region. The fourth unique feature, of course, is its diverse inputs. We are a diverse group and include, among others, practitioners and scholars. The forum is designed to encourage healthy and open exchange of views and gives preference to local voices in the interpretation of a case study. The forum probes these interpretations collectively from a broader perspective. Now, this format allows us to transcend the scholar-practitioner-activist divide and the so-called local and international divide. It allows us to cultivate a diverse but engaged community of professionals in the field of comparative constitutional law. The fifth and final feature of the forum are its inputs. Lena spoke to this extensively. We have policy briefs which are issued under the series Melbourne Forum Constitutional Insights, which you can find at our website as well. Our hope is that we can add to this collection from this sixth Melbourne Forum too, and thereby make a distinct contribution to our current understandings on the outward-looking dimension of constitutions and the dynamics between international law and constitutional law. With that, I'll end my introductory remarks and welcome you once again. Over to you, Anna. Thank you.
Wonderful. Thank you so much, Lena and Dinesha, for really setting out what we have achieved and hope to continue to achieve with the Melbourne Forum this year and into the future. So now we'll move straight into session one, and the theme for our first session is international approval of new constitutions. So one sense in which constitutions have an external face is as a marker of independent statehood, of democracy, of constitutionalism. And as such, over history, many written constitutions have been made and designed with the need to gain some sort of international approval or respect front and centre in mind. And in this session, we want to investigate the context in which international approval is important and think about what the implications of this sense of the need for international approval is for constitution building. So to explore these issues, we have speakers from four very different but highly relevant country contexts. So Afghanistan, where a new constitution was made in 2004 after an international military intervention. We have Timor-Leste, where in 2002 a new constitution was made for a brand new state following a long struggle for independence. We have Japan, where the post-war constitution was made with a heavy degree of oversight from the US occupying forces. And finally, we're very pleased to welcome a little bit at the last minute, speakers from Bougainville, where a peace agreement provided for a new constitution as well as a future referendum on independence. And that referendum was held in 2019 and was strongly in favour of Bougainville becoming independent from Papua New Guinea. So these countries are all very different, with different constitutional histories, affected in different ways by conflict and peace building, by colonisation and decolonisation, and by international involvement in governance at some point and in a variety of different ways. They're of course not the only countries in the Asia-Pacific region and beyond where international approval of a new constitution has been relevant. For example, many countries that became independent in the process of decolonisation were required, or at least felt they were required, to adopt certain kinds of constitutional provisions. Or to take a different kind of example, conflict and peace building are often avenues for international influence in constitution making. So as Dinesha kind of explained in her introductory remarks, the way the Melbourne Forum works is that each speaker is given the same set of questions to respond to. So these questions are set out in the program, and for this session they include the extent to which positive international reactions were a factor in constitution making, the effect that the need for international approval had on the process for making the constitution and on its substance, and the implications of the need to attract international approval for the workability of the constitution in practice and for how state institutions and the people themselves regard their own constitution. So our four presenters face the difficult task of capturing the key insights on these questions in their countries in 5 minutes. We hope you've had a chance to read their written responses to the questions, which you can find on the Melbourne Forum website. And we do have nearly an hour set aside for discussion after the presentations, which really gives us an opportunity to get to the heart of the issues. So we have four highly distinguished speakers, many of whom have contributed to past Melbourne Forums, and I'll introduce each in turn before they speak. So we'll begin with our first presenter, which is Dr. Shamshad Pausaleh, who's a Professor of Constitutional Law at Herat University, and he's going to present to us on Afghanistan. So Shamshad, I'll invite you to take the microphone.
Thank you very much, Anna. I'm glad to be here again, and it's a pleasure to see everyone. And hopefully we can convene in person sometime sooner. The Melbourne Forum, of course, is unique, and because the reasons that Denisha so vividly elaborated earlier. And the themes that it discusses this year could not be more relevant to a country like Afghanistan, where the Taliban government has taken an unprecedented move in getting a constitution from Afghanistan's past, the 1964 constitution, and trying to implement it as an interim constitution. That constitution and the Taliban's own constitutional vision are remarkably different. That constitution's ideals or principles reflected therein or just do not, it's so opposed to the Taliban's constitutional vision. So one has to think of why the Taliban would bring a constitution from the past to implement it as an interim constitution. And the answer that I could think of at the moment is, of course, as the forum puts it so nicely, the external face of the constitution. That constitution has been painted in the literature as Afghanistan's finest constitution, or finest in the Muslim world, to be honest. So that tells us a lot about why the Taliban have taken that constitution. I hope I get a chance to discuss those in the Q&A, but I would take most of this time to just reflect on some of the questions that the forum raises. Afghanistan is a country that has historically attracted the attention of the world superpowers. In the 1800s, the British Empire, and then in the 19th century, the British Empire, and the 20th century, the Soviet Union, and now in the 21st century, as we witnessed the US. Afghanistan's first constitution in 1923 was adopted to signal that Afghanistan has become an independent state. Some of the functions of constitutions everywhere in the world. The outward look or the external picture of the Afghan constitutions become particularly relevant during the second half of the 20th century. Now, this is sadly a period in Afghan history where regimes came to power through extra-constitutional means. And all of them, not unlike the current regime, yearn for international recognition and humanitarian assistance. So that external face or the positive approval of the constitution internationally did play a key role even before the 2004 Constitution of Afghanistan was drafted. But by the time of the drafting of the 2004 Constitution of Afghanistan, the international community, of course, led by the US and UN, were heavily involved in Afghanistan. They had ousted a repressive Taliban regime and then carved out a map for the reconstruction of Afghanistan in the future, for the future in the Bonn Agreement. So the constitution was really drafted and ratified in a way where the external actors kind of had a very close eye on it, interested in some particular constitutional provisions that I will discuss which ones. So the need to have a positive response to the constitution internationally was really a significant one, because most of the international community that was financing Afghanistan's post-Taliban reconstruction were unwilling to provide support or security to the new state if the constitution did not adopt certain design options or certain institutions. That was important. But I would also point out, I think it's important that this is a decorated outward look of the constitution or external picture was something that many Afghans shared themselves, particularly because Afghanistan during the Taliban in the 1990s had become a pariah state, basically a haven for international terrorists, and a country where women's rights and basic rights were brutally repressed. So Afghans themselves tried to use the process and the constitution to signal to the world that Afghanistan is again a friendly member of the international community, not a terrorist safe haven or something. Again, this was a view that was not like widely or universally adopted in Afghanistan. Certain factions that were very powerful in the country did kind of were a little concerned about focusing too much on the external face of the constitution. So this need or this the pursuit for this positive viewing of the constitution did influence both the process and outcome. And I'll shortly reflect on each. With the process, the interim government that embarked upon the drafting of the constitution conducted a remarkable, or the constitutional framers themselves, a remarkably impressive public consultation process. I think was unparalleled probably in the region, even until today. So the drafters of the constitution really traveled to all of Afghanistan, even to remotest provinces. Of course, in 2003, security situation was different than what came out to be later, or even today. They would meet with community representatives, with youth representatives. They would distribute questionnaires and then gather responses. And then I have those responses, those questionnaires that they received back. Is remarkable to look at how the drafters did this. Even they went to Iran and Pakistan to consult Afghan refugees. Now, of course, not all these views were kind of realistically studied by the transitional government and by the framers. But the fact that they did this was to signal to the world, basically, that we are doing something that should be welcomed on the world. So that was the process. As far as the substance, two areas were very of interest to the internationals. One was how the executive branch would be structured, and the other was to what extent the constitution will commit to liberal rights and how that will relate to questions of Islam. And I discussed this on the written piece, but I would want reflect on the executive system that the internationals kind of framed. So the process basically that Alex Thayer was an advisor to the process put it was a big tent and small tent. The big tent was these people's representatives, and the small tent, there were people from the international community and Afghanistan's own leaders like Zalmay Khalilzad. I'm sure the name is not by now familiar to most of you here. And Lakhdar Brahimi, the UN special representatives, were in the small tent, where most of the decisions were. Where the internationals were particularly interested to adopt a presidential system in Afghanistan. Not only a presidential system, but a very powerful presidential system in which a president will sit atop of the executive branch and make unilateral decisions about how international agreements or strategic agreements would be signed. They made different arguments in this, why a presidential system was needed. Some more genuine concerns that Afghanistan was coming out of this conflict in 2001 after the Taliban. And of course, there were a lot of regional notables, as I put it, but some people call it warlords, who had their own militias, and they could challenge whoever was at the center in Kabul. So many Afghans and the international community was one argument was, okay, let's have a presidential system, a powerful presidential system, so that the president could kind of counterbalance the influence or combat the influence of these regional notables, so that they don't pull the state apart. That was necessary. But again, the real reason that particularly the US was interested in a presidential system was, okay, let's do a presidential system so we can get had this discussion with Charmaine and Cheryl on over email, how internationals are interested for a presidential systems in post-conflict state mostly was to just have a sign on a project or an agreement like that. But it was not, the presidential system in Afghanistan was not a universally shared idea. Afghanistan is a deeply divided society. In that system, the presidential system really was an experiment, saying that, okay, we will experiment with this system, and then 5 or 10 years down the line, we will come back and revisit it if it didn't work. Most of the powerful parties or factions to the constitutional bargain accepted the presidential system on this condition that it will be revisited if it did not work. That was how the presidential system was to adopt it, to kind of, please Afghanistan's international donors. And I'll conclude it within one next minute on the implications of it. The consequences, the outcomes of constitutional provisions that were adopted to paint a better picture of the constitution externally, or to have them approved by Afghanistan's donors, had different or mixed consequences. I discussed this in the written piece. But one part that I think had a positive impact was how liberal rights were kind of put in the constitution alongside or equal to the principles of Islam. And for me, it was the framers first say that, okay, all laws, including international human rights treaties to which Afghanistan is a party, should not contradict the principles of Islam. The international said, wait, if you do that, we're out of here, most of them. What the framers did, like, okay, let's give them both an equal status where the international treaties would not have to comply with Islam. But then, okay, again, this is an unresolved question. We will resolve it through the political process. But when it comes to the presidential system, it really turned out to be counterproductive. And by the time the framers thought like 2 or 3 terms, it became evident that the presidential system does not work. Again, Afghanistan loses an opportunity to reform it, and then the rest is obvious for the world. I will stop here. I do want to talk about how these provisions change the behavior of people and of state institutions, hopefully in the Q&A part. Thank you.
Fantastic. Thank you so much. And we'll definitely have a chance to get to some of those additional issues, which are also raised in some of the other papers. So that's really wonderful. Great to highlight both the benefits as well as the costs of this kind of sense of international approval in constitution building. So our second speaker is also a familiar face at Melbourne Forum. It's Adarito Suarez, who was a member of Timor-Leste's Constituent Assembly and the country's first anti-corruption commissioner. And he'll present on international approval and constitution making in Timor-Leste. So Adarito, I'll hand over to you.
Should I put the video or is it okay? Yes.
Yes, all good. We can hear you and see you.
Yeah, thank you so much, Anna. And again, thank you to Professor Cheryl and Shaming for again inviting me for this very prestigious forum. I was so privileged to attend the last one in Colombo when that was about the external actor. And I think that's very much related to what the topic that we are talking today. And I sent this very rough draft paper, and as I'm still working on a full paper for this in order to commemorate the 20th anniversary next year on the 22nd of March will be the 20 years of the adoption of Timor-Leste Constitution, and then on the 20th of May next year will be, this is the first when the Constitution came into power. So we have gone through this 20 years, soon we're going to be 20 years of the Constitution. And it's very fascinating to hear from Dr. Samshad about Afghanistan experience. I was mentioning just in the introduction that, as we are moving to 20 years experience of the Constitution, implementing the Constitution, we are still watching other countries also like struggling with the implementation of the Constitution. I mean, like we adopted the Constitution in 2002, and then 2 years later, Afghanistan adopted the Constitution. And Dr. Samshad mentioned just briefly about the wonderful, remarkable consultation process in Afghanistan, which is, I have to say, we didn't have that kind of privilege for long consultation process. And I think that was one of the main critique for many of observers that, Timor was given very short period of time to draft the Constitution. And when you talk about the international approval to the Constitution of Timor-Leste, yes, I would say that, once we look at the history of the Constitution after the referendum in 2022, exactly, you can see how international were involved in the drafting of the Constitution, because Timor was under the transition process, political process under the UN after the referendum in 1999. Just very brief past experience in 75, on November 28, 75, before Indonesia invaded Timor on December 7, the leading party that at the time fought for the independence proclaimed unilaterally the independence of East Timor, and then they adopted a 55 article of the constitution at the time to show the world that, yes, we proclaim our country. But of course, as we all know, that no international recognition of that proclamation, because it was proclaimed unilaterally, no recognition of UN. So 24 years later, we fought against Indonesian occupation, and then in 99 we have the referendum on August 30, 99, and 2 years after 99 we adopted the first constitution. So just to explain a bit the transition, I mean, we were given by the UN at the time as the administrative power, we were given 3 months to draft the constitution. So basically we have 90 days to draft East Timor constitution. And I was privileged, as Anna mentioned, I was privileged as one of the member of the Constituent Assembly 20 years ago. So I was on my 30th, have no experience on this matter, on this very complicated issue, but I made this joke in the first day of sitting of the Constituent Assembly that maybe we can only adopt a 60 article constitution, because if we count for 90 days, maybe we only have 60 effective working days. Anyway, so to make it short, because of the pressure and then lobby of different actors, the Catholic Church as one of the strong institution on the ground, international advisor, like I think Cheryl Sonder was also there as part of the Asia Foundation international advisor that came on off to advise the Constituent Assembly. And I recalled also a letter from few senators and Congress members of the US, those who in the past kind of supported the struggle of Timor. They also wrote a very nice appeal letter to the Constituent Assembly and to the UN to ask for the extension of the drafting process. In the end, we managed, UN at the time and then Constituent Assembly were in sitting, managed to extend for another three months. So basically we have 6 months drafting the constitution. So it was kind of very short process. If you compare with other constitutional making process, like in South Africa or even in Afghanistan, I think both countries had better constitution process. But in the end, we managed to adopt the constitution on the March 22nd. I will highlight one of the aspects that international community under the UN established also as part of the Constituent Assembly, before the Constituent Assembly was established, was the Constitutional Commission. It was kind of consultative body that conducted the consultation process in all the districts, and they're supposed to take the result and then hand over to the Constituent Assembly when they start the debate the constitution. But my critiques at the time to that kind of system was there was no clear link between the Constitutional Commission with the elected Constitutional Assembly. So Constitutional Assembly was given all the authority to draft the constitution. There is no legally binding whether they should take into account the result of the consultation process that conducted by the Constitutional Commission. Constitutional Assembly itself has had a public hearing, invited different entities to come before the Constitutional Assembly on different topics, but we were only given 1 week public consultation. I recall vividly, we were flown, my team were flown with the helicopter, UN provided a helicopter, flown us to another district in the eastern part of Timor. And, we talked with different entities there, with community, with the churches, with teachers. But let me be very clear, we only have 1 week. We don't have provide, proper information or in advance to, share with the community. So once you have kind of dialogue, you can have this kind of constructive dialogue. So it didn't really dig in more from the community. So I think in terms of the process, it's fair enough that people criticize it's not sufficient, the consultation process. All the political parties that represent in the Constituent Assembly, many of them have their own draft of the constitution. So now let me move a bit to the substance of the constitution, how the international approval was relevant for that. And I think most of the Constituent Assembly members were aware that, you know, we came from a long struggle for our rights, our human rights. You know, for 24 years, you know, we are talking about human rights. We fought for our right to self-determination. So that is very much embedded in people's mind. So there is kind of open mind to see the international influence, especially international values adopted in the Constitution. And in terms of substance, I think there was kind of, you know, modest influence by international community, especially on the Bill of Rights. So the Constitution, you know, in the Constitution we adopt Bill of Rights quite massive there, you know, both civil and political rights as well as economic and social cultural rights. What international community did through the UN, through the Human Rights Commission and other agencies like, you know, Asia Foundation or UNDP, there is kind of harmonization of the language of human rights, yeah? So in some of the articles of the Constitution where, for instance, in some of the article, I didn't put very detail in the draft, but, you know, let's say that in some of the articles says that instead of people, the article of the Constitution will say that a citizen has this right for blah, 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 instead of say that, you know, people have the rights of, you know, freedom of expression or right to health or right to education. So there is very much open-minded of the Constituent Assembly to adopt this kind of language of harmonization of the language of human rights. And it is very interesting when I listened to, and I read a bit of Dr. Samsa's presentation paper on the executive system, on the governance system. Because in Timor, as we know that, you know, you adopted this semi-presidential system. And I recall vividly, I think most of the experts at the time, those who, you know, came to advise, I think most of the experts suggested, you know, proposed that better you adopt presidential system instead of semi-presidential system. Yeah, but I think the main two parties that came to the assembly, Fretilin and then also the second largest party, Social Democratic Party, I think they came with the proposal of semi-presidential system, which is also reflected the 1975 Constitution when those young boys, mostly young boys, proclaimed the unilaterally independence in 75. So in the end, the Constituent Assembly decided to adopt the same presidential system. So I think in terms of substance, I think that was the main aspect that you can see the international influence to the Constitution. I mean, the rest of the the articles on, you know, universal suffrage for election, that is very much international standard. And on Article 9, it stated very clearly about the commitment to adopt, include the international treaty laws as part of the positive law through the ratification process. And the last part that I want to say, I think the connection, the cooperation from the very beginning of Constituent Assembly of the country with the international agencies is kind of builds up, and it's even after the referendum, you still see so many international agencies that still play some kind of important role in terms of empower the country, empower the state institutions such as the judiciary, parliament, to uphold the values that ensuring the international values standards that ensuring the Constitution. And I think that was something that I can say like that. Now, just to conclude, you know, after 20 years, I mean, yes, it's not perfect. We should be open-minded. And I recall vividly my message in the last day of the assembly sitting. I say we should have courage to look at ourselves and to open to discuss in the future. And today, I mean, if you look at the Freedom House report just now, Timor is one of the free country in Southeast Asia, the only categorized free country, free press, freedom of the press. We are on the top of 10 Asian countries. Democratic election, we are still free compared to many of the ASEAN countries. I think I stopped for that for a while, and I'm happy to respond on the Q&A session. Thank you.
Wonderful. Thank you, Adarito. I was going to stop you a bit earlier, but I thought, no, you're almost finished. It's all good. Thank you for a wonderful presentation and a kind of complementary story to the story of Afghanistan that we heard before. So lots to discuss there when we get to the discussion and Q&A. So I'll move to our third speaker, who's Akiko Ejima, and she's another person we welcome back to the Melbourne Forum. So Akiko is a professor of law at Meiji University in Tokyo, where she researches, amongst many other interesting things, the relationship between constitutional and international human rights law. So it's a real pleasure to welcome her again to present on Japan's experiences. So Akiko, I'll hand over to you now.
Thank you very much for your kind introduction. Can you hear me clearly?
Yes, we can. Wonderful.
Excellent. Well, thank you very much indeed for this fantastic invitation. It was so exciting, and particularly, actually, I had an experience to visit Afghanistan, the Constitutional Drafting Commission, by the Japanese government sort of project to have a dialogue with the Afghanistan people and Japanese side. So 4 constitutional Japanese lawyers dispatched to Afghanistan in Kabul. So today I was so excited to hear about the Shamsha's talk, and I hope my talk about the very sort of old story in a sort of comparison. And so I try to focus on what I want to say in this very limited time. If I try to wrap up what I want to say is that because of the very strong involvement, i.e. the US occupation army, the content as the constitution is quite excellent, although it is very concise, because it was just done in 7 days as a part of the US occupation army, and then several months at the Japanese government and the Japanese Diet. But the problem is obviously the drafting process. There is no sort of popular consultation opportunity, which the Afghanistan had fantastic, not only just the public announcement speech, but also the visit to each localities, which is really fantastic. So I try to show you how the Japanese constitution, the present constitution, is written and how the Japanese people perceive. And then probably I would like to stress on the external phase of this Japanese constitution, focus on Article 9, the pacifism clause. So Japan had 2 experiences of actually drafting constitutions where international approval played a very important role in a unique way. The previous constitution, the constitution of the Empire of Japan, was also drafted by a small group of the Japanese elites who needed modernization of Japan to repeal unequal treaties between Japan and the Western countries. At that time, the Western countries could not treat Japan as an equal partner because Japan did not have a Bill of Rights, no democracy, no rule of law. So the Japan really needed to have the 19th century sort of Western style constitution. Probably the priority was not to hear the voice of the people at all. And unfortunately, this experience was repeated in the present constitution as well. The second constitution, the present constitution of Japan, was the consequence of the Potsdam Declaration at the end of World War II. And of course, Japanese government realized that, it is necessary to rewrite the constitution, but the outcome was not satisfactory at all. So the US side considered we can't wait. So they established a small team of the lawyers and some people who are well informed of Japanese situation. And they wrote the first draft in 7 days. But interesting thing is that despite the first draft is written by rather outsider, the longevity and stability and even popularity of this constitution is unparalleled. The oldest unamended written constitutional code in the world. So this is a rather interesting aspect of the Japanese constitution. So but therefore there are some criticisms, but probably I should rather mention how the international community perceived the Japanese constitution. Because of the very strong involvement by the US was so direct that the US and the international society had no reason to criticize the Japanese constitution as an outcome. Japan regained independence in 1951 by signing peace treaty, and probably safely said that the most of the international society accepted Japan as a partner in the world community, although there are some a little bit remaining problems with neighboring countries. And then the important external phase of this constitution is Article 9 of the constitution, so-called pacifism clause, which has been considered a concrete promise not to repeat the past by renouncing war as a sovereign right of the nation and not maintaining land, sea, and air forces as well as other war potential. Therefore, each time the constitutional amendment of Article 9 was proposed by the Liberal Democratic Party, LDP, which is the long-lasting ruling party since 1955, it attracted attention and reaction from neighboring countries. So it's a kind of safe mechanism not to militarize Japan again. But then, of course, the drafting process has been criticized as the imposed constitution after the fact that the heavy involvement of the US was publicized. However, in my eyes, it is too simple to call the Japanese constitution as the imposed one. First, there are two reasons for both sides, Japan and US, to compromise. Japan's side wants to keep the emperor, and then the US side wants to settle the occupation as safe and smooth as possible in order to establish hegemony in East Asia. And second, actually translation is a tricky aspect of the writing a new constitution. So during the translation process, the Japanese side utilized the translation or even abusing the translation in order to put in what they want to have in actually. So because the process was so hectic, so probably the US side did not check the true meaning of the Japanese words. Always the words are ambiguous and general. And as I said, the Japanese constitution is quite general and very abstract. Therefore, later, the Japanese government can put in many things by legislation, including the establishing the self-defense forces. And thirdly, there is a input by the private groups of the Japanese academics, and the US side actually heavily referred to several private bills. And then lastly, the House of Representatives, it is a lower house which is elected by the universal suffrage for the first time, including women. Therefore, it's a kind of semi-constitutional assembly to represent the Japanese people. And this actually House of Representatives made a quite interesting amendment, including the social rights, which did not exist in the US Constitution. So I just briefly wrap up. I need to probably wrap up what I want to say. So as I said, the Japanese people did not participate in the drafting process, but probably the quality of the content might get the acceptance of the Japanese people of the constitution, therefore longevity remain. But at the same time, the worst probably outcome of this process is that the very weak sort of trust in democracy and very strong apathy towards the politics. As I already said in the beginning of this session, on Sunday we had a general election, but the ruling party gained the power again, despite the strong dissatisfaction and criticism upon the present government. The turnout is just the 56%. So this is a kind of, the outcome of the undemocratic process of the writing the constitution. Thank you very much for your attention and patience.
Wonderful. No, thank you, Akiko, for such a wonderful presentation that brought together lots of different themes that we'll discuss in the Q&A coming up. So our final speaker, I'm delighted to welcome Mr. James Tanis. who's a former president of the autonomous region of Bougainville and has been deeply involved in Bougainville's peace process, constitution making, and is the current president's international relations envoy. So Mr. Tanis accepted our invitation at quite short notice. So there's no written materials online, but we are so very grateful to have the opportunity to learn about Bougainville's experiences from you today. So I'll pass over to you, Mr. Tanis. I think you're on mute. Can we unmute? The...
Can you hear me?
That's wonderful. Yes, we can hear you now. Thank you. I'll invite you to start again, please. We missed your introduction.
Okay, thank you, and greetings to all of you. It is my pleasure to participate in the Melbourne Forum on Constitution Making. Let me begin my short presentation saying that Bougainville has not reached the stage of, it's not completed the constitution process yet, the constitution of the new independent country of Bougainville, but I can assure you soon we will get to that stage. Therefore, for now, I will be doing a presentation just on the main features of the Bougainville process so that you can see an interaction between the international community and the Bougainville process. I will start by saying that Bougainville process is founded on a very aggressive ground-up peace-building activities by the fighting factions themselves. So it's really a people-driven process. But from the international community, New Zealand intervention proved very useful. And then the United Nations Security Council approved establishment of the United Nations Observer Mission on the ground, also brought in the international support that Bougainville needed. And also there has been many contributing countries to the Bougainville peace process. So already on the Bougainville peace process, there is a strong international community involvement. And also the international community heavily funded the Bougainville referendum. And also the Bougainville Referendum Commission was chaired by an international chairman, a neutral chairman, former Irish Prime Minister, Honorable Betty Ahern. And then the conduct of the referendum was at a strong international observation when it was conducted. And the referendum resulted in a very high majority of 97.7% in favor of independence. There are two things that I will mention about the referendum result. The first is that the definition of independence as a choice available to the people of Bougainville was jointly agreed between the government of Papua New Guinea and the Bougainville Autonomous Government as independence, meaning a state sovereignty and having institutions at international law and having a membership at the United Nations General Assembly. So it's a full-fledged sovereignty that was granted made available to the people of Bougainville to make a choice from it. And in accordance with the Bougainville Peace Agreement that requires the two governments to consult over a referendum result, the two governments have already completed 2 sessions of their consultation. And in the recent consultation in June, end of June, the two governments agreed on a political timeline. And the Bougainville political timeline said the two governments agreed that Bougainville independence or its final future political status will be declared no earlier than 2025 and no later than 2027. So as we speak, we only have about 3 years to the earliest date on which Bougainville can declare itself independent. So the task of producing a new constitution for Bougainville, a new independent sovereign constitution, is imminent. Therefore, the Bougainville Executive Council has already made a decision to start preparing to establish its constitutional commission, so that preparations to produce a new constitution of Bougainville can go underway. And the first thing that the Bougainville government is looking at is on the question of under whose authority do we produce the constitution. So the immediate choice that the government has made on Bougainville is to follow the Papua New Guinea model. And in 1975 and years leading up to 1975, Papua New Guinea leaders make the representation to the Commonwealth government of Australia, saying that they needed an autonomous constitution, a constitution that has to be produced from the people up, from ground up constitution owned by the people and for the people and of the people. So in that way, the Commonwealth, as the government governing the territory of Papua New Guinea, allowed Papua New Guinea to start working on a constitution through an unilateral process. It means for Papua New Guinea to produce its own Papua New Guinea constitution, the new constitution of the independent state, it did not need any amendment or any changes in the Australian constitution. So that's why we think with the president set already in the constitution making for an independent Papua New Guinea, it will be easier for Bougainville to adopt that model. Means that just as the peace process was founded from the very strong ground-up approach, then supported by international community, we aim to still maintain that spirit. It has to be a ground-up spirit from the people, and it has to be tailored to internationally accepted standards. And I must assure the international community and also the forum that we are confident that we can pull out a constitution in the next 3 years. And I say this based on the experience that Bougainville has. In fact, Bougainville is the most experienced province in Papua New Guinea in terms of producing constitutions for the provincial governments. Bougainville had the opportunity to produce its constitution in 1975 that established the North Solomons provincial government. And one unique feature that was in the North Solomons provincial government that did not exist elsewhere in PNG was the presidential type of elections for the premier. And that principle is being maintained even in the process of making the autonomous government constitution. The next constitution that we had to work on was the constitution of the Bougainville People's Congress. Late President Kabui was the president of the Congress. I was the vice president. Even to establish the Bougainville People's Congress that became the negotiating body to negotiate the Bougainville Peace Agreement, we had to have our own constitution. And the most recent constitution-making process is in the process of making the constitution of the current autonomous government. And for the autonomous government, there had to be an amendment in the national constitution, part voting of the Papua New Guinea constitution to grant Bougainville the space to produce its constitution. The constitution of the sovereign state of Bougainville is going to be different. And as I stated, the Bougainville Executive Council has already made the decisions to start preparing, start recruiting the officials and technical officials and the commissioners so that we can be ready to produce an independent constitution. How do we then get the authority from the government of Papua New Guinea if there's no amendment? We have a view that we will be doing that through a treaty. If you read the peace agreement, and the peace agreement says that the final outcome of the result of the referendum and the outcome of the consultations will be ratified by the Papua New Guinea Parliament. We foresaw that this process on Bougainville will end with a treaty. So we had to be very selective with the use of words to describe the process through which Papua New Guinea will endorse the people, the independence vote. So therefore, currently we are working on the drafts of a treaty And it will be that through that treaty, Papua New Guinea will get grant. We want to negotiate with the Papua New Guinea government so that the Papua New Guinea government can grant the freedom and the space for Bougainville to work on its own constitution from the ground up, without waiting for any amendments on the Papua New Guinea constitution to grant independence to Bougainville, but rather do it through a treaty that grants Bougainville a free space so that Bougainville can unilaterally produce its constitution in the same way Papua New Guinea did in 1975. The next bit of feature that I want to present is that going back to the background of the process, the forum is asking what how the constitutions can reach out to the international standards. In the Bougainville view, it's actually, in my view, it's already happening. The international community is already present through the participation of the peace process, participation in the referendum, participation on the consultation process, so that the international views and concerns can be accommodated in the process of through the process of the constitution making. I must also mention that after the agreement with the government of Papua New Guinea on independence being declared no earlier in 2025 and no later in 2027, the Bougainville government came back on the ground and started a process. It's a process that is running now, currently conducted on the ground, called independence readiness process, because we want to be ready for independence of Bougainville. We do not want independence of Bougainville. We do not want a surprise process. So the process that is engaged in every constituency, every elected member, is tasked to prepare its people, the local governments, the community governments, the women and children, and making sure that we go into economic recovery so that people are able to pay taxes to the government, the new independent government. And the independence readiness, the House of Representatives, the parliaments, they have adopted the UN Millennium Goals, so that we prepare Bougainville to a very high standard. Because after independence, we do not want to become another fragile state. We want to make sure that when the constitution is finished, when independence is declared, we become a trusted member of the international community. For Bougainville, it has been 33 years, about 10 years of fighting, and about 24 years, or 24 or 23 years of peace building. That's why we have been making sure the Bougainville process is very, very. We are not weak. We are not slow. It's just that we are systematic, and that at every step along the way, we do things with approval, with agreement, with a joint agreement with the government of Papua New Guinea. Because there's also one angle in the process of constitution making for Bougainville. We want to make sure whatever we do, we make sure we maintain peaceful relationships with the government of Papua New Guinea after declaration of independence, because in our context, we are not gaining independence from a colonial master. We are gaining independence from another Melanesian brother. And in Melanesia, relationships with the community and the surrounding countries is very important to Bougainville. And I think that is my last piece. I think that are the main features. So I'm just pointing you to how the new constitution of Bougainville may shape up when it comes out. Thank you.
Thank you so much. That's a fascinating insight into a current process happening right now. But also, I think the presentation really just put it into its context of how Bougainville got to this point and PNG got to this point. And I think it's particularly interesting because of the combination of international law through treaty and constitution making happening at the same time. So thank you to all our panelists for such really superb presentations. There are lots of issues to discuss and we have about 40 minutes to do so. So to make all this manageable online, we have different instructions for our invited panelists. So that is our speakers over all the sessions of the forum. And I invite you all to now turn on your videos if you wish to. Discussion's just a lot easier if we can see all your faces. Although please keep your microphones to mute when you're not speaking, just to remove any background noise. And do remember that we're recording the session, so if you don't wish to be recorded, please feel free to leave your videos switched off. So I invite you all to contribute to the discussion, to ask questions of the panelists, to share insights of these issues in your own countries, or to draw out themes and issues. If you'd like to speak, just use your raise hand function or drop me a chat on Zoom or wave at me in the background, and we'll get to, and I'll chair the discussion. For our audience, we'd love to hear from you too. So if you've got a question or comment, please type it into the QA box in the Zoom function there, and I'll read your questions aloud to the panel. So we might take some questions together and then return it to the panel for discussion. Benny Bakani, I'll invite you to comment first.
Thank you, Anna. Can you hear me?
Yes, it's lovely to see
Yeah.
you.
Yeah. Yeah. This is a question maybe for Akiko and the other panelists. How important is the structure of the Constitution? A short and a set of principles in its longevity and sustainable support of the international community. I'm asking this question in the text of the Philippine Constitution, which is a product of a people power revolution. But well, I don't know whether that's a problem, but our Constitution is so detailed. Okay, it was overwhelmingly ratified. It was internationally lauded, but it's so detailed. But at some point, you need to amend it, to make it more relevant, more responsive to present-day problems. But what happens is that it has been extremely difficult to change it for fear that its very foundation, which is the people power Constitution, will be changed as well. So that fear that you're gonna change this foundation. So how important is the structure? How important that it is short? How important that it is just set of principles compared to more detailed constitutions? Thanks, Anna.
Great, thanks, Benny. I might take 2 more questions or 3, and then we'll hand it back to the panel to discuss together or separately. Tony Reagan, invite you to put your question.
Thanks, Anna. Hello to Benny. I haven't seen you in a couple of years, and to Adorito for even longer. 2 questions. One to Adorito.
Yeah.
One of the aspects of international community influence that's not always talked about is the influence of the former colonial power on the shape of the Constitution. And it struck me, I was an advisor on short term in the constitution making process in Timor. It struck me that there was incredible influence coming from Portugal via the experience of Mozambique and Brazil. And that in many ways what was adopted by the Constituent Assembly in the end was an edited version of the Mozambique Constitution. Not entirely, of course, there were other things going on, but it seemed to me there was a huge amount of influence there, and that seems to be a common thing in colonial constitutions. I just wondered whether you might comment on how much that was happening. James, in relation to Bougainville, I was wondering, is there any thought yet about the shape of the Bougainville Constitution for independence, what the content might be? Thanks, Anna.
Thank you so much, Tony. Dipendra, put your question.
Yeah, my question. Thank you very much, Anna, for this opportunity presentation. Can you tell me about particularly about Japanese constitution, because we see an imposed constitution by the external forces. So how much do you feel the ownership of the constitution at public level particularly? Is there any dissatisfaction or disownership among larger population in Japan or not? Thank you.
Wonderful. Okay, so there's two questions for Akiko, but I'll just I'll ask Cheryl if she wants to put her question, and then we can go back to the panel. Thanks, Cheryl.
Thanks, Anna. I was going to wait for the next round, but when Dipendra started talking about ownership, I thought I'll come in here. So when we were choosing the cases for this panel, we were trying to choose cases where we thought international approval might be more than usually relevant. I mean, we know there's an international element in just about every constitution making process these days. But we were trying to choose them where international approval might be seen as being sort of irresistible, either because it was a situation of occupation, as in Japan or Afghanistan, or because a state was seeking international recognition as a sovereign state, as in the case of Timor-Leste and Bougainville. And I think that the four cases have sketched those two scenarios very well, and no doubt there are other sorts of scenarios we could think about as falling into these sorts of categories. But when we were developing this theme, we thought, what's the principal problem about this, or the principal set of pressures to be resolved? If on the one hand you have very significant international influence, and I think there's a really interesting question about who we mean by international community, I might say, in this connection, but we can come back to that. You've got that on the one side. On the other hand, you have a constitution that you want to work in context. And so is the principal issue, or is one of the key issues here, how do you ensure local ownership in these situations? And I was fascinated just to read the cases and then hear them being presented. I mean, Akiko's story, she began by saying this is an old story, but it was an old story with some very new twists for me, Akiko. The ways in which in those very extreme circumstances, Japan nevertheless managed to end up with a constitution that fitted its circumstances, as well as being internationally approved. Query whether that dynamic is still being played out, however. In the case of Afghanistan, Shamshad talked about at least the rights and some of the liberal democratic aspects of the constitution being welcomed by so many people in Afghanistan. Maybe that filled the gap. In Timor, Adarito talked about, at least in relation to the harmonisation of the Bill of Rights, and certainly the constitution's lasted for 20 years, so you assume that the local ownership worked. And in Bougainville, just listening to James, because from the beginning Bougainville has envisaged that this is a constitution from the ground up, it doesn't seem to be worrying terribly much about whether the international community approves particular aspects of it. So I'd be really interested in the reflections of the panel on this. Is this a tension between the need for international approval when that exists and local ownership? And is there anything else that anybody on the panel wants to add to how those two goals are brought together?
Thanks, Cheryl. I think that might be enough to be going on with for now. We might get some responses and then have another round of questions after that. So maybe I'll just go in the order that the panelists spoke in, and invite you to reflect on Cheryl's question as well as the more direct questions that were asked before. So Shamshad, did you want to comment briefly on this issue of ownership and international pressure?
Yeah, thank you, Anna. Right, yeah, I think that's the question of the international. Of course, what we mean by international community, and local ownership is really an interesting one, and I think a difficult one to answer. I think I was following this some wonderful insights shared by Tom and Cheryl on Twitter a couple of months ago, where the idea was discussed, like how we think about the way constitutions are made or the starting points, let's Tom put it, and then we don't pay enough attention the way the constitution is implemented. And now you will have to draft a constitution, but of course how it works in practice, whether the workability is impacted in one way or the other is another important aspect. In Afghanistan, ensured that, okay, it's mixed. With the presidential system within two terms, like 10 years, it became obvious that, okay, it doesn't work. The same actors, foreign actors, who had lobbied so strenuously to kind of adopt a presidential system, then came to kind of broker a different agreement between the two leading candidates of a contested presidential election in 2014 to have a collegial executive, where you basically have a de facto prime minister that they named the chief executive officer. Then again, what that again turned out to be a disaster, and it didn't work. So this is to how much there should be leeway for stuff or questions in influence like that. And this is particularly the tension between the external face of the constitution and local ownership is now, right now as we speak, is at play in Afghanistan, where the Taliban are really, the leadership is facing this question of how we can draft a constitution that would give the regime a decorated external face that will attract at least recognition is what they want right now. And then also to locals, to the fighters who basically fought simply because this constitution, the 2004, was imposed. As they said, it was drafted under the threats of the international, the world's superpowers warplanes. Now, okay, why that was adopted the way it did had a reason. It's now they have to, they're really struggling in this respect to kind of reconcile, to find a way, to carve up a way that will kind of go to a middle ground. What happened in 2004, and I made this point in one of the pieces I wrote when the Constitution was abrogated, was none of these choices that were influenced to a considerable degree by the external actors were permanent. They were drafted for a particular period of time, or they were drafted for the time to make a compromise with the constitutional deferral scholarship, or the constitutional design deferred scholarship altogether depicts it, to kind of have a temporary fix, and then move forward to kind of ratify, to implement those or realize it through the political process in a way that then gives a view or an understanding that the constitution is really locally owned. That went again in the wrong direction in Afghan. So that's what the Afghan context, I think, would say. Yeah.
Thanks.
Thank you. Adorito?
Yeah, I'll start with Tony's question. Good to see you again, Tony. Almost 20 years now. Yes, I guess I will not say that, to use the term former colonizer, because otherwise, like you will question where the Portuguese has influence, and then where is the Indonesian influence, right? We have two former colonizers that colonized the country. So, but I think it's has to be recognized that there is very strong influence of the Portuguese expert. I think that's something that, and also it's very much related to the language, right? The discussion and the whole draft was written basically in the Portuguese language. And then you will see Portuguese lawyers that have been seconded to the parliament, straight from Assembleia da República, the Portuguese Assembleia, that, help work closely with the IPU, International Parliamentary Union, that also was assisted the Constituent Assembly at the time. But I think also to be fair to mention that there were two main drafts at the time. Yes, one is from Fretilin, the leading party, but the other one is also from PSD, the Social Democratic Party, which is the draft that drafted by constitutional law professor, forgot his name anyway, come to my mind later. So it was asked by Shanana Gusmao when he even, when we came to the transition, he asked formally to draft a constitution as the draft for us to discuss. So that was something that on the table at the time when we discussed. And I recall vividly one of the articles that came from, let's say you refer to Mozambique constitution about the citizenship, about whether the acquired citizen can work as the military in the defense force or foreign affairs. Yeah, it was prohibited for acquired citizen to work for defense or foreign affairs. And we had long debate, and it was dropped later on from the previous drop. And then so you are right. I mean, I instead of using former colonizer, because otherwise no Indonesian role at all, I would think that that's very much also linked with the language problem at the time that we had when all the draft were in the Portuguese language. And also, to be frank, also you have the senior member of the resistance, let's mention of Shanana, Ramos Horta, Maria Alcatiri. Most of them were very much influenced by, they were educated during Portuguese time, yeah, and many of them, like Ramos Horta and also Maria Alcatiri, were very much living abroad, influenced by Portuguese. So that is the reality that we have. Now, come to the question of local ownership. And Cheryl and Anthony, you follow very, very clearly. When we adopt the constitution on March 22nd, not all the members adopted, right? Not all the members vote in favor. But when we come to the ratification on the 20th, all of them signed for the constitution. But interestingly, if you see in the last 20 years, yeah, even those who not vote in favor on the 22nd of March, everyone were talking about how to uphold the constitution, all the politicians. And everyone make this reference to this constitution. And I think if I can make this argument, that maybe something that Melbourne Forum can also think about, the post-adoption of the constitution. And I think that's very much important, because otherwise we kind of focus on the process of the constitution. But I think the post-adoption of the constitution, whether we can talk about the long-term civic education or whatever term that we can use. But I think that is, for me, that is most important, because that's at the same time you raise the awareness of the civic awareness of the population, and I think that's very much important. And for me, it is pity that if you talk about constitution, okay, you adopt the process, you adopt and then finish. No, for me, it should be a ongoing conversation in different forms of the constitution. And that's something that I learned from last 20 years. It's not perfect, but I think, we are still debating, have these pro and cons about the semi-presidential system, but still this all put in the context of this constitutional conversation, something that I would like to propose to Melbourne Forum to think about. Thank you.
Thank you, Adarito. And it's certainly something that we do try to include. I think one way to think about it is in terms of implementation. So implementation is part of constitution making and the process of constitution building, but it's a really important point. And it touches on something Akiko talks about in her paper, at least, on the continuing civic education as well. So excellent point. Thank you so much. Akiko, did you want to respond to any of the questions that were put to you?
Yeah. Well, first of all, thank you very much for fantastic questions, which really make me think in a deeper level. Therefore, I cannot conclude yet, but I just want to sort of probably respond as an immature, not mature way. But let me start with the second question: how the Japanese people perceive and accept the foreign forces, particularly the U.S. occupying forces. And it might sound bizarre, but the Japanese people in general rather had a very favorable view upon the General MacArthur and U.S. occupation army, probably partly because of censorship done by the U.S. forces. But at the same time, probably because of the content, ideas, or such as the equality between men and women. For the first time, women got the right to vote and could go to university. And now the world is so open, at least in a legal sense. And also freedom of expression. Formerly, they could not criticize the government. They could not criticize even, how can I say, you can't speak up against the seniority. You know, the feudal idea really also, Confucian idea really bind what you can do, what you can tell. But suddenly you were told that you're free, you can tell anything, you can do whatever you like, you can decide what you want to do as your profession. So this is the fascinating moment after World War II. And probably, I don't know, by experience, before World War II or during World War II, no freedom of expression, it's sort of the censored by not only the government, but also by your neighboring community and so on. Then suddenly you are told that you're free. You have a chance to whatever you want to do. So quite many people are fascinated by this idea. Although the traditional, sort of more conservative establishment might be really shocked by the new ideas. So I can't say that everybody accept. I should say some people accept it and other people rather reacted. Therefore, once the occupation army left Japan and suddenly Japanese government policy became more conservative and tried to water down what the constitution says. And as I said, the LDP repeatedly wanted to change the constitution. So therefore, they tried to, how can I say, not to use the constitution as a national identity. So when you go to the international forum as the representative of the government, they may not sort of talk about the experience of having a new constitution as in a positive way. So they don't use it as the appealing point as the new government and which has a new constitution. And this might relate it to Cheryl's question, the local ownership and the international community. So when you think of international community, obviously in the Japanese context, it's not international, actually it's the US ownerships in a sort of. And then due to the Cold War situation, then the US view is not the world view. There are other voices such as the communism. And then the US itself also got the fear that if they let the Japanese people enjoy the freedom, such as freedom to make a union, labor union, and then it might really push Japan to the direction of communism. So suddenly the US itself tried to sort of restrict the free activities of the people, particularly the labor union activities. So it's really complicated, and probably I would say the Japanese case is the sort of extreme case that lacking the public consultation process is the compromise by giving a good content as the constitution. But which is related to the first question, that how can Japan change the constitution now? And somehow the special majority requirement, 2/3 majority of the two houses, plus national referendum by just majority, this is quite, well, high standard. Then this applies not only the fundamental change of the constitution, but also rather minor change of the constitution. So the Japan is somehow lacking the freedom to change the constitution in according to the rather minor changes of the society. But again, this is, how can I say, this is okay at this moment because the Japanese constitution has many clauses which says the specific content is enacted by the legislation. So as I said, only the fundamental questions like the abolishment of Article 9 or the completely changing the content of a Bill of Rights, such as the discarding the equality between men and women, then you need a constitutional amendment. But as long as the minor changes, these somehow the Japan can do that by changing the legislation, not by the constitution. But the first one is the really, really big challenge for Japan. Thank you.
Thank you so much, Akiko. Mr. Tannis, James Tannis, did you want to respond to any of the questions or this issue of local ownership and international involvement? Well, you're on mute again. We'll unmute you. Yeah, that's
Can
it.
you hear me now?
Yes, that's great. Thank you.
Okay, I will try to make a few statements on the questions. The first thing that I want to share with the forum is that I did not mention in my short presentation that the Bougainville process runs on a strategy that we call it a trident strategy, the three-prong strategy. The first prong is the ground preparations. We have been going through a strong, aggressive ground preparation process to prepare the people through nation-building programs. And also the second to the ground preparation is preparing the government as an institution so that it is capable enough to carry on the responsibilities as an independent country. The second of the two fronts is our relationship, our consultations with the government of Papua New Guinea, because we need, at every step, we need their consent so that it will not destroy relationships with the government of PNG and Bougainville, because Bougainville is going through a peace-building process. We are going through this process in the aftermath of Bougainville Papua New Guinea War. The third prong of the trident is the international prong, because what we are seeking from the international community is international recognition. And we know if we are to be recognized by other independent countries, especially the countries in the West, Western powers, we need to rise up to the level of expectation, practice some internationally accepted standards, build in some externally in the expected principles into the constitution. But the second point I want to say is that I'm not a constitutional expert, I'm a peace builder. But as a peace builder, it appears to me every constitution is drafted in response to an event that happened previously. For example, we are just hearing that the Japanese constitution was drafted after the war. So every constitution has an intention. For Bougainville, we are on a peace building process. So that in response to Anthony's question, I will say that the first and foremost question for Bougainville in terms of the content of the constitution is that what are we responding to? What are we responding to on the ground with our relationship with the government of Papua New Guinea and also with the international community? So for now, while the preparation to establish the Constitutional Commission is happening, is in progress, all I can say at this moment is that Bougainville is going to go for an independent constitution, not in a vacuum. There is a constitution already in place. That is the constitution of the autonomous government of Bougainville. So some of the issues that should be dealt with, that can be dealt with, and in constitutions are already dealt with through the constitution of Bougainville, the autonomous government constitutions. And there are a few features in the constitution of the autonomous Bougainville government that I see them appearing in the new constitution. The first, remember, the Bougainville conflict happened over resource ownership dispute between the local landowners and an international company. So the constitution of Bougainville must respond to resource ownership and define them. The second issue is the citizenship. In the Bougainville constitution, we already have a dual citizenship. For instance, the Bougainville constitution says for those people who are married in Bougainville or their spouses are Bougainvilleans, they are automatically regarded as citizens of Bougainville. So, and then the third feature that I see featuring in the new constitution is that Bougainville is the only government in Papua New Guinea that has reserved seats for women. We have 3 reserved seats for women. And you know, we are a matrilineal society, women on the land, the power belongs to the women. So I see a very big increase in the new constitution of Bougainville to include women in the power structures of Bougainville. And the fourth thing is that the current Bougainville constitution has no opposing chamber. It is a single chamber house that has no organized opposition. And we had to draft the constitution that way because Bougainville was broken into the factions. So we did not want to allow a dual chamber where you have the government and the opposition, because we feared that the old fighting factions might simply become government and opposition, and they will carry their division into the structures of government. And to avoid that, we designed a single chamber house for peace building purposes. But now the war had ended. We are now into normal times. So I can already see an opposition chamber developing in the House of Representatives. And as for local government structures, we have community governments in place already in its constituency. So the local government structures are already in place. So in the end, when we talk about the content of the Bougainville Constitution, in my view, about a quarter of the content of the Constitution is already handled by the current Bougainville Constitution. All we need to do now is to revise it and then tailor it into an internationally accepted standard. So to those other viewers who are new to Bougainville, all I want to say is that, remind you again, we have a trident approach, a ground preparation, our relationship with the national government, and international relations with other sovereign countries. So because we have advanced into the peacemaking process, about 24 years now after the war ended, we are already an advanced society as peace builders. So our constitution, I don't see our constitution tailored in a way that we are trying to defend ourselves against another state or another country, as it happened in other post-conflict states. I think the Bougainville focus will be on simply making Bougainville a better global citizen that can be trusted. I think I will leave the response there on the questions. Even though I said we are locally driven, we still need the international community. Thank you.
Thank you so much. Exactly. I mean, I think the point that we can make about every constitution is that none of it occurs in a vacuum. And there's so many different influences from history as well as internationally. One point that I was thinking about as the panelists were responding to was to just highlight a constitution building favourite, which is techniques of constitutional drafting that are used to sort of balance this question of local ownership and international influence. And I think we've got so many examples that have come out of all the presentations. So deferral, ambiguity, sneaky translation issues that happened in Japan, the deferral to legislation, the use of a treaty, the idea of an autochthonous constitutional making process, and constitutional borrowing. So just to put all those things on the table there that we've noted as techniques of how this kind of need or perceived need for international approval is dealt with in the constitution making process. We're almost out of time, but I did want to go to Joseph O'Connor and just to see, I invite him to ask his question or comment. Joseph?
Thanks, Anna. It's basically
Hello.
Hi, James.
Yeah, good to see you.
Yeah, good. I think all the, as I was listening to all the presentations, I think there are some common themes that run across the four presentations. And I must say they were very informative and interesting as well. So one of the themes that I've picked out from the presentations is this process of consultation, and the other theme is this idea of a dual nature in terms of existence of laws. And in terms of the Pacific, most constitutions were created after Second World War, when there was a process of decolonization in the Pacific. So many of the constitutions they have similar structure, And some of the ideas in the constitutions are mainly coming from, or mainly came from Africa, as Tony has mentioned. And it's partly because many of the consultants and the experts were from Africa and moving into the Pacific, because many African countries were also gaining independence at the time as well. But you know, one of the things which Pacific countries are still grappling with is this dual existence of laws. You know, so you have the constitution, but you also have customary law, which is the source of law that regulates, you know, resources, natural resources, in many states, you know, around land, around you know, so there's an ongoing tension between the sources of laws that are captured in the constitution. So you have human rights, which are entrenched in the constitution of the Pacific Island countries, but you also have customary law as well, which is also part of existing laws as well. So you have there's a dual existence of laws, but you know, there's also there are also issues around competition, and these are issues that many countries in the Pacific are still you know, grappling with. And if you look at the tensions that have happened in the Pacific, for example, Fiji and, you know, even Bougainville, Solomons, it's really around land, around resources, and as a response, there are you know, constitutional discussions around change. So you know, Bougainville, they've gone on to, you know, focus on the process of constitutional change. Fiji, they've changed their constitution 4 times as a result of coups. Solomons, they have been in discussion since 2004 up to now on changing their constitution to a federal, you know, to sort of some sort of federal arrangement, or federal constitution. So you know, these things are what's happening in you know, in Afghanistan and in Japan and elsewhere. I can see it also happening in the Pacific as well.
For sure. Thank you so much, Joseph. You've done half of my job in trying to tie some of these themes together. I think it's a really timely reminder that local ownership in the Pacific and in Asia it includes custom, you know, a source of law that may not be as familiar in the West, but of course, nearly, if not all, countries that we're dealing with in this region, it's a very important part of the law that isn't always reflected in the written constitution, right? This is a little bit like international law out there. It's sort of in the constellation of things to take into account that may not be in the text of the constitution. So thank you so much for that comment. Abdurrahman, did you have a question or a comment that we can just put in quickly into the mix, and then we might have to break?
Brief comment for Samsat. Samsat, if I read about the influence of international community in the Afghanistan constitution making process, usually it was pointed out to the involvement of United Nations or the alliance of Western countries. So I'm just curious if during the Afghanistan constitution making process, is there an influence from Muslim community outside Afghanistan to such process? Because we are known that there is a strong connections among, not only between Muslim countries, but also between many Muslim organizations around the world. So I'm just curious about the influence of Muslim communities outside Afghanistan to such process.
Thank you so much. It's a great question because it reminds us that the international community is diverse, right? And not one thing. I just want to note too that there's a question in the chat that I'm going to sneakily push over to Tom's session because it's about how the incorporation of international law and international treaties are recognised in the Constitution and how that relates to international legitimacy. So I see that there, and I think it's super important, but it's kind of what we're going to talk about next session. So we'll move that over. I think maybe if we can just hear from Shamshad about that last point, and then I might wrap it up. But then, of course, we've got the next session coming up where some of these issues will come up again. So did you want to say anything about the Muslim community question?
Yeah, just quickly. Yeah, again, it gets back to Cheryl's questions about who we deem international communities. By international, do we mean the Western world or something else? During the drafting of the 2004 Constitution, the framers did look at constitutions of Muslim countries like Pakistan, Indonesia, Turkey, and Central Asian countries. But the way that borrowing that could take place did not take place too much from those countries. But today with the new regime that is coming on in power, that is become more likely. But of course, when they look at a country like Indonesia, Malaysia, Turkey, probably not. Towards the end of the last regime, the Afghan government tried to build relationship, particularly with Indonesia, where they would send students in the Sharia faculties in Afghanistan to schools teach law. One is law schools that teach you state law, and the other is Islamic law school, which teach you Sharia law. So those professors or lecturers from there were convinced and even sent to Indonesia. We have 4 of my colleagues and former professors are currently in Indonesia pursuing PhDs, just as a way to kind of, shift the center of religious learning that used to be Egypt and then, India, Pakistan, the Deobandi, to kind of look at a different interpretation of Islam to go. But in 1998, when the Taliban first thought of drafting a constitution, they looked at one of the Islamist parties, a very conservative one in Pakistan, the Jamaat-e-Ulama-e-Islam, led by Maulana Fazlur Rahman. He even provided a draft for the Taliban to kind of, to build on. So with the new government, that could be, but again, with which countries, then again, one has to see. But in 2004, constitutions were read, but not borrowed, if I use that word.
Great, thank you so much. And I'm afraid we'll have to bring this session to a close. It's been a really great discussion and really great presentations. I just wanted to try and briefly draw out some further common themes in addition to the ones that have been kind of raised already in the chat, in the discussion and in the chat. So I think that we get a real sense that constitutions are a kind of signalling device, potentially, that the constitution is one way of many that a country can signal kind of equal sovereign statehood, potentially in an unequal world, for the purposes of international recognition, to promote trade and other kinds of international relationships, or to receive humanitarian, security, or other forms of international assistance. And I think importantly that the discussion highlighted that this isn't just a one-way process, that international involvement from all sorts of different actors itself can be a signal of support for the state and for its constitution, however that appears. A second strand of ideas, I think, relates to the implications of constitution making, where there is a sense that international approval is required. So this can arise at the time of constitution making. And I think we see in relation to procedures a real impact on timing of constitution making processes, but also in relation to substance. And I think I expected to hear that international human rights was one kind of area where international influence was really felt. Perhaps less expected was this international influence on the form of government, and particularly this idea of a strong executive, which I think is a theme that we can pick up in later sessions, particularly in relation to the executive and international relations and foreign affairs. And finally, I think a really important point to emerge was the idea that constitutions made with an eye to international approval, or even with direct international involvement, are kind of not illegitimate because of this. And I think there's a risk, and I think we've talked a little bit about some of the risks that are made, that constitutions where international involvement is heavy may not be fit for purpose. They might face challenges in implementation, but I think the papers presented here show that there's a much more complex relationship between local and international actors of all different kinds. and that this can be quite productive in some cases. In some cases it hasn't worked so well, but in others it's been really important way to generate a sense of national identity and capacity and a place in the world. So thank you so much to all our presenters and to everyone for participating in such a rich discussion. We're going to now take a 10-minute break before beginning session 2, and that will be chaired by my colleague Tom Daly, where we'll be discussing constitutional frameworks for treaties. So what we'll do is we'll leave the Zoom session running, so there's no need for you to log out and log back in again. But if you do find yourself logged out and want to get back in, you can use the same link that got you here for this session. So thank you everyone, and we'll see you again at 3:05. Thank you so much.